Yes.
With respect to this honorable court, I'm G.O. Sadiku for the
Yes.
judgment debtor applicant.
Yes. Thank you. Ruling. The instance motion on notice was filed by the defendant's applicant on the 11th of April 2023, praying this court for the principal relief set out as follows. One, an order of this honorable court setting aside Form 48 issued against the defendant's applicants. Two, an order of this honorable court staying execution of its judgment against the defendant's applicants pending appeal. The motion on notice is supported by a 5-paragraph affidavit and it is predicated on 2 grounds. Also filed alongside is the written address of applicant's counsel in support of the application. A further affidavit with 1 document annexed was filed by the defendant applicant on the 11th of November 2023. In reaction, the claimant's respondent filed a counter affidavit on the 23rd of November 2023 with 2 documents annexed as exhibits, also filed alongside as the written address of counsel for the claimant's respondent. I have proceeded to carefully consider this application and taking due benefits of the totality of the written and oral submission canvassed by the defendant's counsel and that of the counsel for the claimant in support of the positions they held, to which I shall specifically make reference as I consider needful in the course of this ruling. The summary of the facts as gleaned from the affidavit in support of the motion is that the defendant's counsel got the brief of the Attorney General that Form 48 had been served on the defendants. It was further deposed that an application seeking for leave to appeal is pending before the Court of Appeal. The motion on notice filed by the defendant to the Court of Appeal for extension of time within which to file the leave to appeal in motion number CS/ABJ PRE/R, excuse me, /CV/296M1/2023 was annexed the further affidavit as Exhibit MYA1, citing the cases of Bishop David Oyedepo and 3 others versus Mr. Emmanuel Chukwuka Ago and another 2017 LPLER 42864, and Honorable Minister of FCT and another versus Mononia Hotel Nigeria Limited and another 2010 Law Pavilion Electronic Law Report at 4257. The submission of F.O. Ekpa Esquire, counsel for the defendants, is that one of the circumstances a party in disobedience to court order may be heard in subsequent application is if the party seeks appeal against the order of which it is in contempt. Counsel argued that the defendants have filed an application seeking the leave of the Court of Appeal to appeal the judgment of this court out of time, and further submitted that by a combined interpretation of Section 30 of the Court of Appeal Act 2004, Order 5 of the Court of Appeal Rules 2021, and other authorities earlier cited, there is an appeal where there is an application where there is an application for leave to appeal, albeit out of time. Counsel argued that by the pending application for leave to appeal out of time, Form 48, Notice of Consequence of Disobedience of Court Order that was issued against the defendants should be set aside, as doing anything contrary will be going beyond the court's jurisdiction to delve into the matters of the Court of Appeal. In opposition, counsel for the claimant A.O. Onoja Esquire placed reliance on the cases of Okoye versus Okoye, AG Anambra State versus AG Federation, Ngere versus Nkuruket, number 14, citation also applied, and submitted that the law is established that it is the obligation of every person against whom an order is made by a court of competent jurisdiction to obey it unless and until the order is discharged, that while the judgment of a court of a competent jurisdiction subsists, every person affected by it or against whom an order is made must obey it, even if it appears wrong. Counsel argued that there is no competent appeal for the prayers being sought for by the defendant, since the defendant's application for extension of time within which to appeal and application for leave to appeal are still pending before the Court of Appeal. On the issue of stay of execution of the judgment of this court, claimant's counsel further submitted that for consideration of the grant of a stay of execution, the applicant must place material facts before the court and argue that the defendants have failed in their duty to demonstrate any special circumstance to grant the application in their favor. Counsel contends that the claimant is at disadvantage on the balance of competing rights and further argued that the judgment sought to be stayed is principally declaratory, which cannot be stayed. The cases of Abu Karil and another versus Ali, PDP and another versus Sebastian and another, Dangote versus Civil Service Commission, Plateau State, Ifekando versus Uzuegu, Ane versus O2, Inyanda versus Amori, SPDC Nigeria Limited versus Amadi, NACB Limited versus Osu Emelanli. Citation all supplied were cited to buttress his submissions. Now, it must be pointed out that a court of law, a superior court of record for that matter, created by the fountain of all laws in the country, would and should not make an order in vain or just as a mere formality to be ignored by the party to whom it was directed or the court itself. The general rule is that court orders are meant to be obeyed by all parties involved. Thus, the court frowns at disobedience of its orders, particularly by the executive arm of the government, and has used rather harsh language such as a quote, executive lawlessness, end of quote, in describing such acts of disobedience. Indeed, there are exceptions to the above stated general rule and as correctly submitted by the counsel for the defendants. It has been held in the plethora of authorities that a party may not be in contempt or disobedience of court order if 1, the party seeks to appeal against the order of the court, 2, challenges the order on the ground of lack of jurisdiction, or 3, the order ought not to be sustained because there were procedural irregularities in the process of making the order. See the cases of Odogu versus Odogu, 1992, Law Pavilion Electronic Law Report at page 2229, the case of Ogunlaye versus Aina, 2012, Law Pavilion Electronic Law Report at 7877. The cases of Bishop David Oyedepo and 3 others versus Emmanuel Chukwuka Ago and another Supra, and the case of Honorable Minister of FCT and another versus Mononia Hotel Limited, Nigeria Limited, and another Supra, cited by the defendant's counsel, are also apposite. In expounding on the interpretation of the word appeal, the Court of Appeal in the cases of Malam Hassan Saidu and another versus Madam Buka Aruna Pelola, 2016, Law Pavilion Electronic Law Report at 40801, and Ugochukwu Chijoke versus Dr. Mrs. Ekenem Kuabam and another, 2022, Law Pavilion Electronic Law Report at 5720, held that by a combined interpretation of Section 30 of the Court of Appeal Act, 2004, and Order 6, Rule 7 of the Court of Appeal Rules, 2021, an application seeking for extension of time to appeal against the decision of a lower court has the same effect as an appeal itself. In his submission, the defendant's counsel placed reliance on the above cited cases and argued that the defendants have a valid appeal pending before the Court of Appeal and thereby urged the court to set aside Form 48 issued by this court on the defendants. I should state that the cases relied upon by the defendant's counsel are not on all fours with the instant case. In the Saidu case, leave to appeal had been filed by the respondents before the actual leave to do so was granted by the Court of Appeal. The Kobam case was in respect of the ruling of the High Court of Cross River State that dismissed an application for an order of certiorari and restored the earlier order granted and the execution levied thereto. In both cases cited by the defendant's counsel, Form 48 had not been issued and served on the judgment debtors before they filed their motions at the Court of Appeal, praying for extension of time within which to appeal. In the instant case, the claimant judgment creditor had approached this court to cause Form 48 to be issued on the defendant's judgment debtors. From facts deposed in the affidavits of the defendant's applicants and the counter affidavit of the claimant's respondents, parties are adamant that judgment of this court was delivered in favor of the claimant on the 28th of July 2022. Thereafter, on the instructions of the claimant, Exhibit B1 and Exhibit B2, that is, letters dated the 29th of August 2022 and the 13th of December 2022 were written to the defendants inviting or demanding them to comply with the judgments of the court, and that Form 48, notice of consequence of disobedience of court order, was issued on the defendants on the 22nd of February 2023, having failed to comply with the order of this honorable court. As deposed in paragraph 3A, B, C, and D of the affidavit in support of the instant application, and as endorsed on Exhibit MYA1, Form 48 in contention had been served on the defendants on the 22nd of February 2023. Before Exhibit MYA1, the motion on notice was filed on the 1st of March 2023 by the defendants at the Court of Appeal seeking for an order of enlargement of time to apply for leave to appeal in the Court of Appeal. Put differently, as at the time Form 48 was served on the defendants, there were no appellants by law, either by the filing of a motion for extension of time for leave to appeal or by filing a notice of appeal, albeit irregular, within the context of the interpretation of appeal or appellant by the authorities. And as so hold, the general principle is that a court is functus official once it has decided a matter on its merits, and in that situation, the same court cannot sit on an appeal over its decision to vary it or set it aside, as that will be contrary to the doctrine of stare decisis or precedents. See the case of Cytec International Estate Limited and another versus Francis and others, 2014, Law Pavilion Electronic Law Report 22314, and the case of NCS Board versus Lawal, 2024, Law Pavilion Electronic Law Report as 62774. Once a court delivers its judgment on a matter, it cannot revisit or review the said judgment, except in any of the following instances and circumstances. 1, where the judgment is obtained by fraud or deceit, either in the court or of one or more of the parties. 2, where the judgment is a nullity. 3, when it is obvious that the court was misled into giving judgment under a mistaken belief that the parties consented to it. 4, where the judgment was given in the absence of jurisdiction. 5, where the procedure adopted was such as to deprive the decision or judgment of the character of a legitimate adjudication. Seen in this instance, the case of Igwe versus Kalu, 2002, 14 Nigeria Weekly Law Report, part 787 at page 435. In the instant case, none of the conditions warranting a court to set its judgment exists or order exists. The applicants are not complaining that the order was obtained by fraud perpetrated by the claimant. There is no complaint that there was a mistake by the courts. The applicants did not complain that there was no service of the court's processes on them. The order was not given in the absence of jurisdiction. The court was not misled into giving order under a mistaken belief that the parties consented to it. Lastly, the procedure adopted was not such as to deprive the decision of the character of a legitimate adjudication. The order of court has no feature that will render it a nullity. The complaint of the applicants is that they had filed a motion on notice at the Court of Appeal to extend time within which to appeal for leave to appeal. To apply for leave to appeal. Form 48 having been issued prior to the filing of the motion at the Court of Appeal cannot be set aside by this court. In the circumstances, therefore, the jurisdiction to set aside the said Form 48 does not lie with this court any longer. The power lies on the appellate court, and I so hold. On prayer 2 for stay of execution of the judgment, it is settled that the court must ensure that a successful litigant is not lightly deprived of the fruits of the judgment awarded in its favor. The court must also ensure that the intending appellant's constitutional right to appeal is not impeded in any way, and also, more importantly, that when they exercise that right successfully, the result is not rendered nugatory. It was held in Imba versus Udruan, 2009 Law Pavilion Electronic Law Report 19777, that a discretion that is biased in favor of an applicant for stay of execution but does not adequately take into account the respondent's equal rights to the fruits of this judgment as a discretion that has not been properly exercised. Therefore, in order for the court to maintain the appropriate balance and be assisted in ensuring that its discretion is not only judicially but also judiciously exercised, an applicant seeking the equitable relief for stay of execution of judgment must satisfactorily establish the existence of some special circumstances, in this case, that should warrant the grant of the order sought. See the cases of Vashuani Trading Company versus Savelak & Co., and the case of Okafor versus Naife. Citation supplied. I had carefully examined the totality of the facts deposed in the affidavits filed on behalf of the applicants to support the present application. The pertinent question now is whether, on the basis of the facts presented to the court by the applicants, there exists exceptional or special circumstances that will sway the discretion of the court in depriving the respondent from enjoying the fruits of his judgment pending the final determination of the appeal set to be lodged. Of the purported appeal. Apart from stating that an appeal for extension of time for leave to appeal has been filed and a copy of the motion on notice exhibited, the applicant did not state any other facts that will sway the mind of the court in its favor. The mere filing of the application, as it were, without furnishing the court with materials for consideration of granting of the prayer is fatal. In totality, having failed to show any special or exceptional circumstance to sway the mind of the courts in their favor, the present application is hereby refused, and it is accordingly dismissed. Parties shall bear their respective costs.
We are grateful for this ruling, my lord.
Yes. So having not granted the application to set aside the Form 48, where do we proceed from here? Mr. Onoja, you've started with your not hearing you, hearing
sorry,
you from
Lord.
afar.
I'm very sorry, Lord. I'm saying that this case number has been successfully determined, and they will be applying for another date to take a necessary step with respect to Form 48. Form 48 follows with Form 49.
Yes. So
we'll be asking for another date to take the necessary steps. Hey, please, my Lord.
Okay. But I'm aware that you filed the garnishee proceedings in respect of this case in another matter.
Yes, my lord.
The garnishee is in respect of the monetary.
It has a different file number.
Because you made it to be so.
And we have
Why
been
do you
directed to
have?
on
Sorry,
issue of account.
Is not that is not what I'm saying. Why do we have a garnishee proceedings in that matter?
The garnishee proceeding is a monetary judgment and a restatement.
Okay. It's for the monetary judgment, while this one is for the reinstatement.
For reinstatement.
Okay.
Yes, my lord. Yes, my lord.
So we take the 21st of May.
Most grateful, my lord. Most obliged.
Is it convenient?
Yes, my lord.
Respondent, applicants rather, the judgment debtors is 21st of May convenient?
Yes, my lord, it's convenient.
Thank you. I'll return the staff and still have to endorse it. So call the next matter, please.
Case number 2, NICN LKJ 36, 2023, between Barrister Momo N. Baba and Federal University, Lokoja and others.
Parties absent, appearances, please. Yes.
With humility, my lord. AY Monday. I recently appeared for the defendant's applicants.
I didn't hear your
Sorry,
name.
my lord.
AY.
AY Monday defendant's respondents.
Okay, thank you.
Did you file everything?
Who is appearing for the applicant?
My lord, sir, I'm supposed to be in the matter, but I'm rendering assistance, and the assistance is being taken for granted. I think I have to ease myself out of the matter.
So no legal representation for the applicant. Okay, ruling. The claimant commenced this action by complaint filed on the 23rd of November 2023, wherein he prayed for the reliefs of those courts. The instant motion on notice was filed by the claimant on the 19th of April 2024, seeking the leave of court to amend his complaint statement of facts and witness statement on oath. Annexed to the motion is Exhibit A, the proposed amendment. I have given due consideration to the said application and the facts deposed in the affidavit filed to support the same, the proposed amended processes, the totality of the written and oral arguments canvassed by the claimant's learned counsel in support thereof. The defendants did not file a counter affidavit but opposed on point of law. According to the facts deposed in the affidavit filed to support this application, particularly paragraphs 4, 5, and 6 thereof, the need by the applicants to amend the originating processes was essentially due to the inadvertence of clear understanding of computation of figures and to make available some facts and documents that will further assist the courts to determine the case. In opposition, counsel for the defendants argued that there is no prayer supporting the changes made in Exhibit A, the proposed amendment, and further argued that the prayers sought in the motion are unsupported by the facts in the application. The question that the court must now determine is whether, on the basis of the totality of the circumstances of the case, it is proper to grant the amendment sought by the claimants. As it is well known, an application for amendment can be made by a party at any stage of the proceedings before judgment, and a court in determining whether or not to exercise its discretion in favor of granting the application must be guided by laid-down principle enunciated and handed down from time immemorial by judicial precedents. See the case of Gowon versus Ike Okongu, the case of Oyeyemi versus Irewole local government, citation supplied. The overriding ground for granting an application for amendment is basically to ensure that the real issues in controversy between parties are brought to the attention of the court for proper adjudication. In Alstom Essay versus Saraki, 2014 Nigeria Weekly Law Report, Part 687 and 415, the Supreme Court appositely encapsulated the principles of amendment when it held as follows, I quote, in law, to amend any legal process affords a party, whether a plaintiff or a defendant, and even the appellant and or respondent on appeal, to correct an error in the legal document. Amendment enables the slips, blunders, errors, or inadvertence of counsel to be corrected in the interest of justice, ensuring always that no injustice is occasioned to the other party. The weight of judicial authorities leans in favor of allowing a party to amend its legal processes whenever the need arises in order to ensure that the real matter in controversy between the parties, shorn of manifest errors, mistakes, and slips, is adequately brought to focus and determined with the proviso, however, that the right of the adverse party is neither unduly compromised nor unredressed. End of quote. The last point that is necessary to be made in this regard is that once the justice of the case so demands, the court can grant an amendment at any stage of the proceedings. In the Locos Classicos case of Oja versus Ogboni, 1976, 1 All Nigeria Law Reports at page 4 and 146, the Supreme Court also held inter alia that the only grounds upon which an application for amendment will be refused by the court are where it will entail injustice to the other party, or where the party seeking amendment is acting mala fide, or by its blunder, the applicant has done some injury to the respondent, which cannot be compensated by costs or otherwise. I have proceeded to examine the substance of the amendments sought by the claimant applicants as set out in the proposed amended complaint. Amended originating process. The contain facts and figures which, according to the applicant, will be necessary to meet his case, but which figures were inadvertently computed, and the facts will assist the court in the just determination of the case. The question in the circumstances, what prejudices, injury or injustice, will the defendant suffer if this application is granted? In order to meet the additional facts sought to be introduced in the proposed amended state originating process of the claimant, the defendants are thereby entitled to file a consequential amendment. Therefore, I totally disagree with the submission of the counsel for the defendants that the proposed amendment is inconsistent with the facts as contained in the motion. In my view, the focal purpose of this present application is to afford the claimant the opportunity to put forward all facts available to him and to assist the court in determining the real issues in controversy between the parties in the suit. It is my further view that more injustice will be done to the claimant if this application is refused, as his right to fair hearing would not have been seen to have been protected. On the other hand, whatever inconveniences caused the defendants by this application may be redressed or compensated in costs. As I have also stated in the foregoing, the right of the defendants to file a consequential amended statement of defense is not foreclosed. Ultimately, the focus of the court is to ensure that it is seen that justice is evenly handedly served to all the parties at the end of the day. In the final analysis, I find merit in this application. The same shall be and is hereby accordingly granted. The amended complaints of the claimants bearing the endorsements prescribed by the provision of Order 26, Rule 8 of the Rules of this Court, together with all accompanying processes, shall be filed and served within 7 days from today. Parties shall bear their respective costs. Yes. Yes, I can hear you again.
For a date to enable us peruse the newly amended and then make consequential amendment to our own defense.
Okay. I must sound a warning on the claimants, though, that they, by the rules of this court, they have only 2 times to amend. They've exercised the first opportunity. So they should be careful, because once they say they want to amend the second time, they will be foreclosed from further amendments.
Let's go, please. This sounds very much
The 22nd of May, please.
Let's go, please. Second.
22nd.
Okay. Thank you. Thank you, my lord. It sounds similar, right?
Yes.
Search number 3. NICN KJ 34, 2024 between Momo Jimo Onipe Idri and 1. Kogi State Local Government Service Commission. 2. The Chairman Kogi State Local Government Service Commission. 3. Ajokuta Local Government Area Adogo. 4. The Chairman Ajokuta Local Government Area Adogo. My Lord, claimant is present. Defendant absent.
Appearances, please.
May it please my lord.
Yes. CA.
TA.
Is your last name that I can't hear and I still cannot hear it? Okay, the one that has money. Okay.
Very well, my lord.
Okay, so who is for the defendant here?
The defendants are not, my lord.
No legal representation for the defendants. The matter is just coming before the courts for the first time.
Very well, my lord.
So it's for mention.
Very well, my lord.
Okay, I do not have yes. We have proof of service of the originating processes on them.
Very well, my lord.
So by the rules of this court, you still have to file a motion to set down for trial, just so that we are sure that they really do not want to proceed and we can proceed on our own side.
Very well, my lord. We agree, my lord.
So I'll give you another date for further mention to set it down for trial.
As the court places, we are most grateful, my lord.
22nd of May for further mention.
We are most grateful, my lord.
Court cases adjourned to the 22nd of May 2025 for further mention. Hearing notice shall be issued and served on the defendant.
As the court places, we are most grateful, my lord.
Thank you. Yes.
Case number 4. NIC and LKJ 10/2022 between Joseph Francis and Sinoma International Engineering Company and another. My lord, parties are absent.
Parties are absent. Appearances, please.
May it please my noble lord,
Yes.
I'm P. Ahmed.
Yes.
I appear for
Yeah.
the first defendant, my lord.
Yes. No representation for other parties.
No, my lord.
Yes, Mr. Amen.
No, my lord.
Yes. What are we here for today?
My lord, the matter is for hearing this morning, my lord.
Yes.
However, sir,
Yes.
now that the claimant nor his counsel is in the court, sir,
Yes.
and this has been their character. That has been their character since the filing of this suit, my lord. This 2022 matters suit, sir.
Yes.
It has been coming to stop all along 2022.
Yes.
So this morning, sir, we shall humbly, sir, be applying that this should be strike out. So that when the claimant is ready, the defendant are always available. They can come to court again, sir. They have just done this case since 2022 and have not been attending to the case, sir. So humbly, we urge me, Lord, sir, to evoke the power of this honorable court in order 38, row 3, and strike out this matter, sir.
Thank
Most
you.
grateful to me, Lord. The claimant have not shown any good reason for his absence this month. Another is here represented, sir.
Courts, by the records of the courts, the claimants and counsel have been absent from courts. In the circumstance, it is safe to infer that they are no longer interested in the matter. I shall be granting the first defendant counsel's application for striking out of the matter. The matter is hereby struck out accordingly for want of diligent prosecution.
Most grateful to me, Lord. Most grateful to me, Lord, sir.
Yes.
Number 5.
Should come there.
Between Ibrahim and the Gifted government and 3 others. My Lord, parties are absent.
Parties absent, appearances, please.
Yes, my lord.
Yes.
May it please me, Lord. I am A. Onoja. My appearance is for the claimant.
Yes.
With respect to this honorable court, I'm G.O. Salisu. My parents for the defendants.
Yes. Yes.
My lord, the matter is for further mention.
That is not the correct position. Matter is for hearing today.
Okay, my lord, very sorry for that. Since the matter is for hearing, my lord, on our part, we are not ready to go on, my lord.
Why are you
We
not
are
ready?
very, very sorry. The reason is that our defense is ready, but we are having a little challenge in filing it.
Mr. Onoja?
I'm not opposed to his application, my lord.
The 29th of April.
As courtesy.
29th.
29th.
As court pleases, my lord.
Most grateful, my lord.
We are most grateful, my lord.
Thank you. Court case is adjourned to the 29th of April, 2025 for hearing.
As courtesy. Most grateful, my lord.
Yes.
Case number 6, NICN LKJ 29, 2023, between Idris S. Lami and Kogi State government and 2 others. My Lord, claimant is in court. Defendant absent.
Claimant present. Defendant absent. Appearances.
May it please me, Lord. I am
Yes.
A. Appearing
Yes.
with Paul Ahmed.
Yes.
Announce your appearance.
Yes. No legal representation for the defendant.
There is, my Lord.
May it please my noble Lord.
Yes.
Lord, I, A. Ahmed, Senior Legal Officer.
Mr. Onoja, you said Paul Ahmed is appearing with you.
Paul Ahmed.
Okay, so we have another Mr. Ahmed. That is what I wanted to be sure.
No, my
Ahmed.
Lord.
Paul Ahmed. This one is Ahmed.
For the defendant, my Lord, sir.
Okay, your own is Ahmed.
Yes, my Lord.
Okay, I said thank you.
JH, my Lord.
Okay, thank you. For the defendant, yes?
Your own is on number.
Yes.
My Lord, sir.
Have you filed your amended statement? Or who amended the last?
there is an amendment we did.
Yes, Mr. Onoja.
Matter is for hearing.
Matter is for hearing. Yes.
Yes, my lord. The leave of court, we are ready to proceed.
What did you not amend at the last sitting?
Yes. We only amend the complaint.
Okay.
Only the complaint.
Has the same been served on the defendant?
Yes, my lord. They have been served.
Yes, Mr. Ahmed.
Well, sir, we have been served. We do not intend to. We are ready to go on.
Okay, you are ready to go on without filing your defense?
Yes, ma'am.
The defense
I've
has been
recorded.
served.
We have
Yeah,
filed
has
our
it been-
defense, my lord.
Oh, I see. We filed our defense. You don't intend to amend. We do not intend to amend
Okay.
our
No
defense.
consequential amendment, my lord.
Yes, you said you don't intend to have a consequential amendment?
Yes, my lord.
Okay, case 2 down then, if you're ready.
Yes, my lord. Thank you.
Thank you, my lord.
Yes. Yes.
The claimant has entered the witness box, my lord.
I said case 2 down, case 2 down.
I've
So
got it,
I'll run. Okay, yes.
Okay.
Can you call the
I've
next
got it.
matter?
Case number 7, FL.
Yes.
May please, my lord.
Is the judgment creditor present?
Yes, my lord.
Judgment debtors absent and garnishes.
Please, my lord.
Judgment
This is
debtor
motion
present.
expert. We are not supposed to be inside. My lord, is a motion expert.
Yes, it's a motion express in which you are to file an address to supply the need for us.
Whether or not the account to be supplied. Yes, my lord. His address. My lord, ready to proceed with them, my lord.
Yeah. The address has been filed.
Yes, my lord.
I saw your long address. The only
Sorry, my
answer,
lord.
the only reply that the court has for you for this your long address is for you to look at order 51, rule 2,
H.
So you know
Yes,
about
Lord.
it. Okay.
I've addressed on that, my lord, sir.
Okay, so you say we shouldn't comply with the rules of our courts because it is what?
My lord, where there is rule and there is law, the law supersedes the rule, and that is
And so
important.
which law brings NIC Acts? Don't we have NIC Acts, and are we not backed by the Constitution?
The NIC Act is subservient to Sheriff and Civil Process Act when it comes
That
to
is what
enforcement
you
of
think. No, that is not. This is how we've been operating. Anyway, I will give you a ruling, a date for ruling, if it's that you want, and it will prolong your matter. The people that have supplied their account number, that is a case after you now. They supply their account details. I will grant them the order. But if you are still insisting that you want to go by the law, I will adjourn this ruling and I will give a proper ruling on it, and until then, I cannot do anything.
My lord, sir, what we are trying to say, I'm very sorry that we are taking the time of the court.
You are not taking my time. You are taking your own time. It's not. We are developing the law.
We are very sorry. They have multiples of accounts. If we are able to get one, they will shift from that one to the other. So
okay,
did not come out.
So because of
normal
that, I
practice,
should
and what
bend the rules for you and say that you shouldn't supply their account.
Sir, we are not saying bending the rule. We are saying that section 83 to 87 of the
Okay, that's why I said I will
has
give a
been
considered ruling on it, so that any other person that comes after you is just to copy and paste the ruling for them. I won't even bother. So it will be like a test case for me.
Beloved, sir, even the judgment you delivered, the ruling you delivered in the first matter says no law permits a judgment creditor to be denied of his labor injustice.
This is a process of the court. It is not denial. If your process is defective, the law cannot grant you. You comes with equity, must come with clean hands.
Pathway to justice. The rule is a pathway to justice. It's not
Okay.
a hindrance.
There's no point in me arguing with you. Let us just meet when we rule.
No, beloved, we are still pleading with the court to still be humane in this issue. I've done so many garnishing before your lordship and your other learned. We have come a long way with this matter,
okay, thank you.
Beloved, we are still pleading with your lordship to give it a well-considered humane consideration, beloved, sir.
I will.
Milord, this is trying to ask for the impossibility. And doing the impossibility, the Lord does not recognize it, Lord, sir.
Okay, I've heard you. You've addressed the court. I have the right to rule on your address, don't I? So let me rule on the address.
My Lord, we are your children here.
On this one, you have not won. Court cases adjourned to the 20th of May, 20. No, I can't even give you that date. The 22nd of May for ruling.
As court cases. Most grateful, my Lord. My Lord, sir.
Yes.
May I apply that it will be given an earlier date, then we can try and supply the.
When you supply it, I'll give you an earlier date.
I can try and supply tomorrow, the one that is available with us.
When you supply, I will give you the earlier dates. But as it is, I have a ruling. Thank you. Yes, the next case.
Yes, number 8. NIC and LKJ 30M 2024 between Mrs. Yusufu Ajuman and Kogi State University and
Who is absent? The parties are absent. Appearances, please.
With profound respect to my noble lord. My lord, my name is L.N. Ilobuno.
What's the name?
L.N. Ilobuno. My lord, I appear with Elias Omeni for the applicant, credit applicant, my lord.
Elias Omeni.
Yes, my lord, for judgment creditor applicant.
Yes.
My lord, in compliance with the directive given by my lord.
Yes.
My lord, we file affidavit on the 14th February 2025.
I've signed it. So you can move your application. I said I've signed it. You can move your application for the garnishing.
Physics. My lord, before my lord is an expert application.
But before then, you have another motion that you filed on the 5th of November. What is about that motion?
Yes, my lord.
You have two applications filed on the 5th of November. One is for the garnishee, and the other is to grant to enforce.
And here
Can you-
is not. I'm not.
You can't hear. I said you have two pending applications.
My lord. No.
You have two pending applications. What is the other one?
My lord, the application that is right for hearing is the expert application.
So what
The other
about
one
the
has
other?
not been served.
So can you have a garnishee and then have another of courts for leave to enforce judgment? That is what I'm asking.
No, my lord, the other one is on notice for the contempt proceeding. For the contempt, I mean to say, to commit the respondent for disobeying, because the judgment is for reinstatement of the judgment creditor, while the expert application is for the enforcement of the monetary claim.
Monetary order. Okay, I hear you. Okay, so you can
Yes, my
move
lord.
the expert.
Yes, my lord. Before my lord is an expert application. Dated is an expert application with motion number NICN/LKJ.
When was it filed, please? When was it filed, please?
It was filed, my lord, dated 5th day of November 2024 and filed the same day, my lord.
Yes, you can proceed.
My lord, the application is seeking it was brought pursuant to the relevant order as contained on the face of the motion paper, my lord.
Yes.
My lord, the application is seeking for an order attaching the sum of 3,001,000 naira only, any part thereof as may be standing, to the credit of the judgment debtors respondent with the garnishees.
And all this, okay, you've limited the number of the garnishes that we are to attach in your further, or we are to attach 3 million on 17 garnishes.
My lord, we limited it to, in compliance with it, to 3 banks, which we have shown the account.
Okay, to UBA alone.
To UBA, EcoBank, and Polaris Bank.
The accounts that you supplied, okay, Polaris, UBA, okay, thank you.
And the EcoBank, my lord.
I didn't see EcoBank in this.
My lord, EcoBank is there.
Number
EcoBank
what is Eco? Number what?
EcoBank is in paragraph 5, Roman figure 4.
Okay, thank you.
Yes, my lord.
On the face of the motion paper, thank you.
Yes, my lord.
It is
my lord,
supported.
we are even asked, my lord, we are further asking for 500,000 naira cost.
Cost of
for
what?
this garnishee proceeding.
That is very presumptuous because you don't know
500,000.
It is when it is at the absolute stage that you ask for cost. You cannot ask for cost at this stage because you don't even know whether they have this funds with them.
As cost, please. As cost, please.
Okay, your motion is supported by how many paragraph affidavit?
My lord, supported by 7 paragraph the affidavit.
Yes.
And then next to the affidavit is deposed by litigation secretary Abubakar Bachu in the judgment creditor applicant law firm.
Yes.
My lord, and next to the affidavit is exhibit 1. That is the judgment of this honorable court delivered on 22nd April 2024.
Okay. With one exhibit annexed.
Yes, my lord. That is the judgment of this honorable court, delivered on
Okay.
22nd April 2024. My lord, in compliance with the rules of this honorable court, we qualify written address dated 5th November 2024 and filed the same day.
Yes.
And finally, my lord, we file affidavit as directed by my noble lord on the 14th day of February 2025. Deposed by the litigation secretary of the judgment creditor applicant law firm. My lord, we rely on all the averment and all this process in order, my lord, to grant this application. This thing is no Sunday now.
Yes, I'm here. I'm writing. It's because I'm writing. Sorry, I should have told you. Okay. You said you've also filed the further affidavit on the 14th of February 2025 to furnish.
Yes, my lord.
Furnish the account details.
Yes, my lord. Of 4 banks.
Of the judgment
UB.
debtors.
Yes, my lord. My lord, the only thing that we appeal to my lord is that the more especially Kogi State government, they have different accounts with the bank that we listed. They have many accounts with the bank that we listed so far in the further affidavit. So we want a situation where my lord will not limit it to a particular account, since we have shown that they have accounts with those banks.
Okay.
Thank you, my lord.
I think I will just limit it to the accounts that are relevant to the case, because it's a case dealing with the university. So I'll just look at the accounts in relation to now the State University Ayigba. I cannot garnish all their accounts. That will not be justice on the part of the court. The Kogi State University Ayigba account, the one on number 5, the one on number 6. Those are the ones that I will limit them to.
As for this, my lord, the reason why we are saying is that the money in that particular, they may not have money in that particular account, but they will have money in another account with the bank. So limiting it to
well, the point is that if we ask them to show cause on all these accounts, you know that the accounts will be on hold until we discharge them, and then the state government will not be able to operate too.
No, my lord, what we are saying is that they should show account cost. They can print, they can give a show cost for any particular account that has money. It doesn't mean that they must show this thing for all the bank. But what I'm saying is that limiting it to a particular account. What if they don't have money in that particular account? Because I'm aware that they have different accounts with this bank that we have said so far. But tying the other to a particular account, it may turn out that that particular account, they don't have money, but they have money in another account with the bank.
Okay, thank you.
Thank you, my lord.
I'm in the process of writing the ruling, so that may take a while. Okay. I said I'm writing the ruling, so you cannot hear anything when I'm not talking.
At first pages. At first pages.
Court. Application granted. Another NISI is hereby issued to the following garnishes, namely United Bank for Africa PLC, Polaris Bank, Eco Bank, to show cause why they shall not pay the applicant the sum of 3,100,000 naira only, awarded in favor of the applicant in suit number NICN/LKJ/05/2023. The judgment debtors had failed and or refused to pay, and which sum now stands to the credit of the judgment debtors in the accounts with the following garnishee banks.
Such cases. We are most grateful, my lord.
Please, before you are grateful. 1, Kogi State Government SRA accounts with number 10029443334 UBA PLC. 2, Kogi State University Thetford account. 3, Kogi State Operation account. And 4, Kogi State University Anyigba, and 5, Kogi State Government Revenue account. The order shall be served on the judgment debtors and the garnishes. The garnishes shall show cause within 14 days of being served with the order. The matter is further set down till, let's say the dates to give you now. Till the 30th of April, 2024, for garnishes to show courts.
As for cases.
30 April 2025. For garnishes to, so it is only 5 of the accounts that I utilized. If after those accounts they still don't have anything, we can always come back and issue on the remaining 2 accounts. Thank you.
As court cases. We are most grateful, my lord.
Yes, the case stood down now.
And state government and 2 others.
Yes. Is the witness in the witness box now?
Yes, Lord.
Yes.
Did you ask that?
In the name of Almighty Allah, that the evidence I shall give you shall be
Yes.
Thank you, my lord.
A sworn on the Quran, I believe, or affirms. Registry.
Register.
How was the oath taken?
He sworn the Holy Quran.
Yes, you can proceed.
Thank you, my lord. Take the court. Speak out.
My name is Ibrahim.
Speak out so that if you say the
Maybe she should just step out of the witness box. We assume that she is in the witness box and get close to the speaker.
Ask up is most grateful, my lord. Return the return. Let's use this one.
Yes.
Thank you. You remember you supposed to in this court?
I cannot hear you again, Mr. Onoja.
Speak out very well. I said, did she remember that she be posed to 2 statements on oath in this court?
Yes. Yes, sir.
The first one was on the 7th of 3, and the second one is on the 19th of March 2024.
Yes, sir.
7th of August
7th of August 2023, my Lord,
and
and 19th of March 2024.
yes.
Do you adopt them as evidence in this case?
Yes, sir.
Huh? You see the same thing, man. The same thing.
Court's witness depositions made on the 7th of August and 7th of August 2023 and 19th of March 2024 are hereby adopted.
This is most grateful, my Lord. Do you remember that you led evidence to certain documents in your statement on oath?
Yes.
Speak out now.
Yes, sir.
The
Yes.
documents are listed at page 23 of the main complaint.
Paragraphs what? I will rather you give me the paragraphs than the page.
I will ask all places. Sorry, my Lord, then I have to go over. My Lord, I was thinking that since it is listed on the list of documents.
Oh, okay, you have the documents in one
Yes,
at
page 23 of the main complaint.
Okay.
Thank you. If you see those documents, can you recognize them?
Yes.
By what means?
My name's the documents.
One. The salary ones.
And the salary of government.
What did you say about something about salary?
Salary implementation. Hussein, please come. Show her. Are these documents? They are arranged serially. See her here now. Sit down.
Yes.
Serially, they are arranged serially.
Here's my
See, this is how you do it. This offer of
appointment.
Temporary appointment.
Temporary.
Permanent
Appointment letter. Posting letter. Confirmation.
This is a minimum wage.
And promotion
letter.
And here is my certificate.
Results.
The other documents are certificates?
Yes, the relevant document, other relevant document, certificate, not.
Certificates of institution or educational certificates?
Yes, senior secondary school certificate.
Okay.
Below the claimant has identified the document as listed on page 23 of the complaint, and we seek to tender them in evidence.
Yes, defense.
Show it to me.
Another, I'm trying to go through the documents.
Yes, you can. Please don't waste the time. Yes. Mr. Ahmed, we are waiting. These documents were front-loaded. When they are you just checking whether they are the same as the front-loaded ones? You're muted, so I can't hear you. Are you talking to the courts? If you have to, unmute. Yes, what is your reaction to the tendering of the document?
Yes, my Lord, sir. My Lord, in respect to some of the documents, they are not objecting the offer of provisional appointment, letter of offer of pensionable appointment,
Yes.
notification of promotion, and the school certificate.
So which one are you opposing? I cannot hear you. I still cannot hear you.
My Lord, can you hear me, my Lord?
I can hear you now.
Yes, my Lord, sir. The document titled Ministry for Local Government and Chieftaincy Affairs.
That's the implementation of payment of 18,000. Is that the document? You are on mute again.
The public document. Sorry, my Lord. The public
Okay.
term was never there. There was no
I cannot hear you.
certification from the issuing authority.
No certification on which document?
The document titled Ministry for Local Government and Chieftaincy Affairs.
Is that the one that is on the list as number 5, Mr. Onoja? Mr. Onoja, is that the one that is listed number 5?
That is the one that is listed number 5.
So that's the only one you are objecting to the admissibility.
What is the heading? What is the heading? That's number 3.
He is objecting to number 3 too.
Yes, Lord. Okay. What of?
So which ones are not? Are you not opposing? Can you give the ones that you are not objecting to the registrar? Let her have it so that I will know which ones you are not opposing.
Number 1, number 2, number 4, number 6, and number 7.
1,
1, 2,
1, 2, 4,
6,
okay.
and 7.
What is the ground of your objections to 3 and 5? I'm sorry, I'm really, I don't understand why I cannot.
My stance of objection is that they are public documents. And same were never certified by the issuing authority, my lord, sir. Like I'm muted. Thank you.
Mr. Onoja, what is your reaction?
My reaction to it is listening to the Lord. There is no opposition to appointment and confirmation of appointment. Is it that he did not post the staff? That is posting later and it will be issued to the claimant that is being presented. You are not opposing, secondly, my lord, sir, you are not opposing to appointment of your staff. Are you not paying the staff salaries? So
Is that
yes, my lord, that claimant is showing that I've been paid this salary and this is what I've been receiving. Even in their defense, there is no objection to the fact that they are paying salaries to the claimant. So this is an empty objection, my lord, sir. And by section 12 of National Industrial Act, sub 2, the court has been enjoined to shift away from technical ground on certain
Oh, now,
issues.
Mr. Onoja, you can use Evidence Act, which is, we can use section 2 now of National Industrial Courts. But you cannot use sheriffs and civil process when it comes to National Industrial Courts.
And no, Lord, I'm talking about the law of National Industrial Court, section 12.
Okay, so now National Industrial Court Act applies in this case. It is not applicable in the other case.
No, Lord, these are laws. Section 12 of National Industrial Court law is law. And it says that the only can shift away from technical grounds when justice is prominent rules of evidence. It's just talking about rules of evidence, which your law says you can shift away. So I urge your lordship to this objection. You pay salary to your staff, you posted your staff. Do you employ somebody to put the person in a particular place, or you put that person to you're only showing that you can pay your salary. There's no dispute to that. For that reason, what you objection. They are immaterial to the and what the essence of evidence is the document of relevant, they are all relevant documents to show that I've been employed and I've been employed, I've been paying salary, adjustment to salary. The essence of the document has nothing to do with it.
Court, the documents sought to be tendered are pleaded and relevant. Pursuant to Section 12 Evidence Acts, the court shall depart from the rules of evidence and admit the said documents. The documents are admitted and marked as follows. 1, offer of provisional appointment, dated the 5th of October 2004, as Exhibit C1. 2, offer of pensionable appointment, dated the 5th of April 2005, as Exhibit C1A. 3, posting of staff letter, dated the 10th of July 2006, as Exhibit C1B. Confirmation of appointments, dated 12th of June 2006, as Exhibit C1C. Letter of promotion, dated the 26th of June 2008, as Exhibit C1D. Implementation of the payment of 18,000 Naira minimum wage. Approved consolidated salary structure, forwarded to the local government area councils as Exhibit C2. The what did you say is the certificate? Is it WAEC certificate or something? You are muted. What certificate
NECO
is
senior certificate?
NECO senior certificate?
Senior school certificate, yes.
As Exhibit C3, respectively.
As copies. As copies. Most grateful, my Lord.
Yes.
My Lord, that will be all for the claimant.
For the exam in chief, you mean?
Yes, ma'am.
Yes, cross-examination, you have 40 minutes. It is important that I hear your questions clearly, so you move close to the device so that I can hear you.
Can you tell us your report?
My name is Ibu. Take your name.
Yes.
Where
1980.
I was born in 1980. Yes?
Can you tell us your report when you were employed?
I was employed on 5th October 2024. News of Agri.
5th of October 2020.
October.
Yes? Which year?
5th October 2004.
Okay, yes.
You are very much amazed that by 2009 screening of the provincial government, your appointment was
I didn't hear that question. I've told you that you have to be clear so that I'll know what I'm writing down.
Of your appointment in 2009.
No, not directly because I work.
Learned Defense Council, I didn't hear your question.
that she was released, that she was released of her appointment in 2009.
No.
She was what?
She was released. Her appointment was terminated.
Okay, she said no, it is not true that my appointment was terminated in 2009. Yes?
No, ma.
Yes, I've recorded you.
Yes. Since 2009, I've never been at your place of
No.
What is no? Have you been at your place of work since 2009?
Yes, my lord.
my lord.
Go to the front. Go and sit by her.
Right before and I'm not comfortable with that.
Shift. Let me see. Go and sit by his side. Sit by his side.
Yes, I've been at my place of work since 2009. Yes. Yes.
Yes, you have nothing to show that you have been in your place of work since 2009.
I've been working with Minister of Africa. I work under Commissioner, FAMSEC, and Director of Accounts. I'm a full staff. So, to a stage when the salary was not paid, I cannot be affording transfer from my place to work. Yes.
Yes.
Which one are you saying now? Me not been coming or what? That is our question. Since 2009, you have not been coming to work.
I've been coming.
Yes, she said she has been working in the Ministry of Agriculture since 2009. Yes.
Yes, my lord. You have nothing to show this court that you've been going to work since 2009 to date. You have nothing to show this court.
Do you have anything to show that you have been going to work since 2009?
Like I said, I work under the commissioner. FAMSEC, right before
We did not say you are
2001.
not working on that. Do you have anything to show us that you've been going to office? That's what we're asking.
I'm be going to work, ma'am.
Okay, so you can proceed, please.
Yes. What is the name of the current commissioner for agri?
Yes.
I don't know the name of the current ones, ma'am.
I do not know the name of the current commissioner for agric. Yes?
Yes, you equally do not know the name of the current director of admin. It's a question. Please answer.
Yes, do you know the name of the director of admin?
Reason for that, no more.
I didn't hear you.
No, ma'am, for a reason.
Yes.
Yes, you are a clerical officer from your clinic. Directly under the director of admin. Am I correct?
Yes.
Yes. Yes.
Yes. Can you tell me how old you were when you were employed?
Cannot I I know I was born 17th May 1980.
What year? 17th of May, what year?
1980.
Okay, yes.
Now, you are aware that by the civil service rule, promotion is not a surprise. Are you aware that promotion is not a surprise by the civil service rule?
No.
I'm not aware. Yes.
So I put it to you that promotion by the civil service is by vacancy. You only get promoted by vacancy. You are aware of that?
I I know that it's by the year employed and the effects of your work.
Yes. Yes.
What is your highest qualification?
O level.
Yes.
Well, that will be hard for the
Thank you. Re-exam. Yes, is that the claimant's case?
Neil,
Yes.
Yes, my lord, that's the claimant's case, my lord. That's the claimant's case, my lord.
You are discharged. Yes, defense. How many witnesses do you have? I didn't hear that. One witness.
Was she dismissed because she does not know the name of the
Okay, the case is adjourned to the 22nd of May, 2025 for further hearing.
As court places. As court places, 22nd May.
May.
Yes, my lord, we are most grateful. Amen.
Yes, the courts will rise. Thank you.